Last time we were looking at collective bargaining and how is it that a union and an employer come to an agreement. And we covered that in extensive detail. This week we're going to talk a little bit about this idea of picketing and strikes. In other words, what happens if the parties don't come to an agreement? Or what happens if the parties come to an agreement but one side thinks the other side is breaching that agreement? And that's where you get into picketing and strikes. Now, we're doing this particular session in the studio. Many times when I have done this in a live session in the past, I ask people what to define for me picketing, I ask for them to define for me patrolling, I ask for them to define for me strikes. And they will tell you, or if I just say, what is a strike? They will tell you, well, it's where people get up, they hold these placards taped to a stick, and they march back and forth. Generally, that's what the public thinks about as a strike. But it's really a little more involved in that, and because this is a labor law class, we want to get into the actual definitions of those things. And so, basically, strikes, picketing, patrolling, boycotts, lockouts, those are all pressure tactics used by, depending upon what it is, whether it's by either the union or the employer, to try to get the other side to come and see their point of view. And we call those pressure tactics, all right? Let's go through these pretty quick. Some of them you will be familiar with, some of them you may not be familiar with. But let me give you the terms and you can see how when you say, well, that's a person on strike, it may be more than that. One of those pressure tactics, let me just list them for you. We have picketing, we have what we call picketing. We have what we call patrolling. We have what we call strikes, and then we have boycotts and lockouts. Now, when we're talking about picketing, picketing is simply where you place persons outside an employer's premise to convey information to the public by words, signs, or distributing literature. All right? So, let's say that I'm a member of the construction, the plumbers union. Let's go back to the plumbers union. Let's say I'm a member of a plumbers union and I'm unhappy with a particular construction company's processes, and I think they breached an agreement. I even have an agreement with them and I think they breached it. What I can do is have a person simply stand outside the premises and hand out literature. That would be what we would call picketing. Now, many times people think, well, picketing is where you walk back and forth with the signing. No, that's another pressure tactic that we call patrolling. Patrolling is actually the movement of persons back and forth around an employer's premises. So I can have patrolling whether I have the signs or not. If I have the signs and the people are simply standing still and I have one person out there posted with a sign, that is simply picketing. If now I take that person as a union, if I take one of my union members, give that person a sign, and now have him walk back and forth and around the employer's premises, now I'm engaging in what is called patrolling. All right? Technically, I could patrol without even having a sign. So you can do picketing by itself, you can do patrolling by itself, but they're much more effective if they're combined together. And that's generally what people see. Then you get, so when we talk about pressure tactics, you have picketing, you have patrolling. You also have what we call striking or strikes. And this is simply the organized withholding of labor by workers, all right? This is generally the weapon used when workers or union members are attempting to pressure employers into a particular situation. We call that striking because they withhold labor. And if they withhold labor, then the employer is not being able to get its products produced. And if it can't get its products produced, it can't sell them. And if it can't sell them, they're losing money. And that's how and why the strikes are an effective and generally the traditional weapon by which labor unions attempt to pressure employers. So you have picketing, you have patrolling, you have strikes. You also have boycotts by unions where they simply say, we're not going to, and we encourage others not to patronize this particular place of employment. Okay? That's what we call boycotts. You can also have the employer use a weapon saying, you know what, we've tried to get you to work to us and agree to our $20 hour wage and you've insisted on 40. Guess what? we've worked it in good faith. We're not going to work with you anymore. By the way, we're going to shut the door, and you're not coming in. Okay? So the lockout is really the opposite of the strike, or it is the employer's version of the strike. Whereas the strike is by the union members saying, we're not going to do any work. The employer uses the lockout to say, you're right, you're not going to do any work because we're not going to allow you to do any work, and we're not going to pay you for what you don't do. Now, what we're talking about here, what we've been talking about in collective bargaining, what we're talking about here in terms of these remedies or these pressures, the strike, the picketing, the patrolling, that is mostly in the private care sector. And I say private care sector, really the private sector. We talked in this class at lengths about differences between private industry and governmental industry. And we're going to finish up in our very last class session, we'll actually talk about public sector or government relations. But in the private sector, keep in mind, healthcare is a little bit different. You know, we already talked about in the collective bargaining standpoint for healthcare, you may have to give at least 90 days notice, where generally in the private sector you only give 60 days. Same thing when it comes to strikes is different in the healthcare industry, and that should make sense. But according to Section 8G of the National Labor Relations Act, if you're a healthcare industry union and you're going to go on strike, you actually have to give written notice of the striking or the picketing or any other concerted refusal to work at least 10 days prior to the beginning of the strike or the picketing. And that makes sense. When you're talking about healthcare, you're talking about people's lives. And if you suddenly had all doctors or all nurses of a particular union say, we're not going to show up tomorrow, that would create a huge catastrophe. And so notice of that in the healthcare industry is a little bit different. Whereas you may not have to give notice in other circumstances, you have to give notice before you go on strike in the healthcare industry. This allows the healthcare institution to make arrangements for patient care. And so that makes sense. For public sector employees, and we'll talk about it a little bit in our last class session, there may be no right to strike at all. Because there is no constitutional right to strike. That's been tested. People have said, well, wait a second, I have a constitutional right to strike. And remember, as we've talked about in this class in units past, private sector doesn't have to necessarily follow the Constitution. They have to follow laws, but not necessarily the Constitution. Public sector employees are guaranteed constitutional rights. And some of those have tried to strike, have been fired, and it's gone up to the courts, and the courts have said, you know what, there is no constitutional right to strike. You have a right to join organizations, but not a right to strike. Strikes by private sector employees are regulated again by the National Labor Relations Act. These strikes are also regulated by Section 7 of the Norris-LaGuardia Act. And that seriously has restricted the ability of federal courts to issue injunctions in labor disputes. So generally, in a private sector situation, if everything is followed correctly, if they've gone through the process of trying to negotiate, if they've gone through in a collective bargaining situation in good faith, courts generally, and there are exceptions, but generally cannot come in and interfere with a private sector strike. So keep that in mind. Private strikes is, in fact, an activity in the private sector that is protected. The National Labor Relations Act recognizes strikes, recognizes the ability to engage in strikes, and so protects that. There are certain provisions, and we're going to cover those, that say there are some things you can't do. And in terms of picketing, remember, striking is withholding of labor, but picketing involves movement back and forth, or I'm sorry, holding a sign in front of a particular employer's premises. Well, the National Labor Relations Act says, fine, if you've got a problem with an employer, you can picket on their premises, but you can't engage in what we call secondary boycotts. And we're going to get into secondary boycotts in just a minute, but that's the idea that my beef is with this particular employer, but in order to get to that employer, I'm going to boycott somebody else. Again, we'll go ahead and give you the example right now. Let's say that I'm a union. I don't even know if Mattel has unions, but let's say that Mattel is producing its Barbie doll, and in the production of the Barbie doll, that the Barbie doll is produced by union workers, all right? And these union workers are unhappy about the fact that they are only getting a $10 an hour wage as opposed to a $17 hour wage. There would be nothing wrong if they go through the process of negotiating in good faith. There would be nothing wrong with those union members striking, if you will, or picketing or patrolling Mattel. Nothing wrong with that. That's who their beef is. On the other hand, the National Labor Relations Act says, hey, you can't take that farther than your own premises. So you can't take it to, say, Toys R Us and try to picket or patrol Toys R Us because your beef is with Mattel. And we'll talk a little bit more about some of that secondary boycotts. The National Labor Relations Board also prohibits picketing for recognitional purposes. Now, that's limited. There's some exceptions, and we're not going to get into all of that. But remember, picketing is trying to get somebody to do. It's a pressure tactic to try to get the employer to do something. For the most part, the National Labor Relations Board says, if you're a union, but you're not recognized as the union that this employer must deal with, you can't picket in order to force the employer to deal with you. Let's say I'm plumbing this Union Association 427, and I come to this construction company and I want them to hire or to use us, to recognize us as the union, and we don't have a vote and we haven't had an election. I can't, as that union, just start picketing or patrolling in order to force that construction company to recognize us as a union. That's prohibited. Other prohibitions, and we'll talk about some of these in more detail, but violence. Violence is absolutely prohibited as well. And so the National Labor Relations Board has some regulations that they put into effect. State interests also. There are many state statutes, and we won't try to cover all of those, but state statutes also have some regulation of picketing, some regulation of patrolling. Generally, again, it's to prohibit violent picketing, where not only are they having handbills, but to the extent that it rises to the level that they're shoving them in people's faces or things of that nature, that would be violent picketing. Both the NLRB and some states prohibit what we call mass picketing. And so depending upon how many people, can you have more than one? Absolutely. Can you put 1,000 people in front of a little Dairy Queen store? Absolutely not. That would be mass picketing. And so the idea is you can picket, but you can't actually interfere with the business. Now, you would say, well, even one picketer interferes with the business. Absolutely correct. You'd be right. The idea is you can't prevent people from coming on to the employer's premise. So you can't have so much mass picketing or so many people out there picketing and patrolling that it's going to scare people away. And so those are, while it's recognized, there are certain prohibitions against it. Well, let's talk a little bit in more detail about this recognitional or organizational picketing and get that a little more detail. It is a violation of both the National Labor Relations Act or a violation of the National Labor Relations Act to prohibit or to engage in this recognitional picketing. It is particularly wrong when the picketing is done to force another union. For instance, if I've already got a union and I'm recognizing a union, then I can't engage in recognitional, or the union can't engage in recognitional picketing. Give you an example. The employer has recognized a particular union. Another union can't come along and start picketing to try to enforce or force the employer to recognize the second union. You also can't have recognitional picketing when a representation election has been held within the last 12 months. Let's say I'm an employer, let's say I manufacture TVs, and let's say that a union has come into my plant and has tried to have a union set up amongst the employees. Remember how we talked about getting unions recognized, all right? Let's say they have the election in the manner consistent with the law. But let's say that they didn't or were not able to get the majority that they needed. In those particular situations, if I've had that election on my premises, or if there's an election that's been held within the last 12 months, then it is a violation of the National Labor Relations Act for a union to come in and say, we know we lost that election, so now we're going to picket and you've got to recognize us. Not if I've had an election within the last 12 months. That's simply not allowed. And then finally, picketing to force an employer to recognize a union is also prohibited when the union pickets for a reasonable period of time without filing a petition for an election. So if they're not even trying to get it, then simply it is not valid. And those are the situations where recognitional picketing is simply not allowed. Now, again, like everything, there's an exception. If the picketing is to advise the public that an employer does not have a contract with a labor organization, that may be okay. Okay, so you have to just look at organizational picketing or recognitional picketing. When is it allowed? Generally, it's not allowed. There are a couple times when you can get around that. And that's what we call recognitional picketing. Remember, we also talked about secondary picketing or secondary boycotting, or this idea that I'm really mad at Mattel, but I'm going to take it out on Toys R Us. That is what we call secondary picketing. It is picketing to pressure a neutral party. Toys R Us didn't do anything wrong. They just sell the dolls. And really, the dispute is not with Toys R Us. The dispute by this particular union would be with Mattel. And so the National Labor Relations Act says, you know what? We're going to prohibit secondary picketing when it deals with a neutral party to the extent that you're trying to force an employer to join a labor organization, to the extent that you're trying to force a person to cease doing business with another person. We're going to prohibit it to the extent that an employer is being forced to recognize a union when another union has already been certified. And we're going to prohibit it when an employer is assigning work to employees of one union opposed to another. And so basically you can't use secondary picketing in those situations. Now, sometimes you can use it if individuals are allowed to refuse to cross a picket line. It may be okay. And sometimes secondary picketing is all right with regard to publicity. In other words, to advise the public, other than picketing itself, but publicity to advise the public of the products that the primary employers are being distributed by another, or primary employers are being distributed, or primary products are being distributed by another employer. And so you get into this idea, what I think I want you to take away from this is, for the most part, secondary picketing is not allowed, but there are some times when it is allowed. Now, in our Mattel situation, where we talk about Mattel and the union workers at Mattel and their beef is with Mattel, not Toys R Us, that's real easy to determine who is the secondary employer. In that case, if I were to ask you who is the primary employer, you would say that it's Mattel. If I were to ask you who the secondary individual or the neutral party would be, or even a secondary employer to that extent, you would say, well, that's Toys R Us, and you'd be correct. Section 8B of the National Labor Relations Act protects employers who are not involved in a dispute with a union from being pressured by that union. That's why they prohibit the secondary boycotts. That's why they prohibit the secondary patrolling or the secondary picketing. Now, to determine whether or not, how do you determine that? In the Mattel Toys R Us analysis or analogy, it's pretty easy, but sometimes it's not so clear. So how do you tell? And the NLRB has given us, and the courts have given us, a series of factors that we can look at to determine whether you're dealing with a primary employer, at which picketing, patrolling is all allowed, or a secondary employer, which picketing and patrolling generally is not allowed. And here are some of the questions you have to ask, and we'll put these on the PowerPoint as well, on Blackboard. With whom does the union have the dispute, right? Is the dispute really, let's go back to Mattel just because it's easy. Is the dispute really with Mattel, or is the dispute with Toys R Us? If the dispute is about wages, and Toys R Us has nothing to do with my wages as a union employee, then the dispute is with Mattel. And at that point, it's easy that Toys R Us is the secondary employer. Also the question, is the union picketing at the primary employer's premise, or is it the side of a neutral employer? If my beef is with Mattel, then why am I picketing Toys R Us? All right? Why am I not over here at Mattel? Now, obviously, you know the reasons for that. I may have more people at Toys R Us than I have at the plant at Mattel. But with that in mind, that tells you who the primary employer is. Am I really picketing, or am I violating the law if I'm picketing at somebody else's, some neutral party's side, if you will? What is the purpose of my picketing is another question the courts look at. Am I picketing a Toys R Us, if you will, to force Toys R Us to stop doing business with Mattel? Because I can have a lot more impact if that's the case. If I'm doing that, then it's probably illegal. Or am I intending to simply inform the public that the Toys R Us handles the Mattel product? If I'm doing that, then it may be legal, as we looked at as one of the exceptions. So those are sometimes some of the questions that courts look at in deciding primary versus secondary. Again, in our society today, what comes into play is premises often move. In other words, it's easy in the Mattel situation. You have a plant that is very local, it's fixed, you know where the plant is. Sometimes, however, businesses are mobile and they move from site to site. And so we have what is called ambulatory situs picketing. Ambulatory situs picking. And that's simply if the primary employer's business is mobile, then picketing by following that mobile location is called ambulatory situs picketing. Let's say we have a trucking company that really, yeah, you may have a facility where the trucks are, but really let's go bizarre. Let's say we got, you've seen these mobile taco stands around. Well, let's say the workers at those taco stands are all unionized, all right? I don't think they are, but let's say for the purposes of this example that they are. If that taco stand happens to move from one lot to the other lot, let's go back. Let's say that taco stand is placed outside the Toys R Us lot on one day, and the next day it is placed on the Great Southern lot, and then the next day it's placed on a Walmart lot. If I, as a union employee of that mobile taco business, go from Toys R Us to Great Southern to Walmart, I'm engaged in picketing. Is it legal? Right, it is legal. And the reason it's legal is because I'm following the primary employer that moves, all right? Ambulatory situs is allowed if my focus is actually on the taco stand. Now, let's say take that same situation, and I've got the taco stand that moves from Toys R Us to Great Southern to Walmart. If the taco stand is at one corner of the lot, but I'm doing my picketing at an extreme opposite corner of that same lot, then it's probably not going to be allowed because the focus are not going to be legal. Because then at that point, I'm doing more than just trying to influence the taco people. I may be affecting somebody else's business. And so keep that in mind in our mobile site. Same thing with regard to another term frequently used is common situs picketing. And this is simply when you picket an entire site because of a dispute with one contractor. This probably makes sense more in the construction industry. And let's say that I'm a construction person working, let's go back to the time that John Q. Hammond's Arena was being built, all right? I don't know that there were any disputes in connection with that building. Don't think there were, but let's say there were. And let's say that I'm a plumbers union and I'm coming in to the northeast location to work on a particular bathroom or plumbing site over there. If in that particular case, I'm a union and I want to picket, if I'm focused on where the plumbers come in and where the plumbers work, then that's going to be all right. If, however, I'm picketing another part of the John Q. H. arena where plumbers are not going into and an area where plumbing is not needed, then that may be illegal. Let's say I'm picketing again at the John Q. Hammonds Arena, but let's say this time the plumbers are not even coming in for the next week. At that point, I need to stop my picketing, because if my focus is on a particular contractor or subcontractor, then and the plumbers aren't even there, then I can't, that would be illegal. If, on the other hand, I'm picketing where they come in, when they're working, that's generally going to be allowed. So again, you get into that a lot more nitty-gritty detail. The one kind of exception to all this is what we call the alley doctrine, A-L-L-Y doctrine, because not all picketing directed at somebody other than the primary employer is prohibited. Secondary boycott prohibitions are intended to protect neutral employers from union pressure. Mattel versus Toys R Us, all right? That's a good example. On the other hand, an employer is not neutral if it is performing the work normally done by the workers of the primary employer who are now on strike. So let's say that I have a local employment agency, and let's say that my strikers on Mattel are the ones who they're striking, and my beef is with Mattel. If employment agency A over here is providing all of the work that was done by the striking, it may be okay, not in all situations, but it may be okay to actually strike the employment agency as well, even though they are not the primary employer. And the reason for that is there is an exception, this Ally doctrine, that is carved out when work is performed by the workers of the when other workers are performing the work for the primary employer. So if you've got employees that you're borrowing back and forth, then it may be okay. The other time that picketing may be okay, as we talked about, is what we call consumer picketing. And we mentioned this earlier. If the purpose of this picketing is to inform or truthfully advise the public that the secondary employer is handling the product of the primary employer, then that's okay. Let's go back to our Mattel situation, but let's say for whatever reason that the workers of the Barbie doll, they're not bothered by the fact that they're making $10 an hour, $17 an hour, whatever it was that we decided upon. They're bothered by the fact that in making these Barbie dolls, there is a part in there that will cause a chokeable, is dangerous, if you will. The part that comes off and kids get choked on it easily. If that's the case, and that's really, they think they're having to work in, or they're using a product that in creating the Barbie doll, let's go this way, if in creating the Barbie doll, they're using a product that is actually dangerous to them, and it has some kind of chemical effect. In that case, they may also be able to picket Toys R Us, who handles the product, in order to say, hey, not only does Mattel create this product that is dangerous to your kids or dangerous to our health, but Toys R Us is carrying this product. And in that case, that's what we call consumer picketing. Courts generally allow that. The National Labor Relations Board generally allows consumer picketing, certainly allows them to distribute handbills that are addressed to the public saying, support our union by refusing to buy this Barbie doll, if you will. It is generally legal unless it has the effect of inducing other employees to refuse to perform their services at the secondary employer's location. In other words, I can tell the public about it, but if I'm getting to the point that I'm trying to keep Toys R Us employees from doing their job, I may have literally crossed the line, so to speak, and created a problem that is not allowed. The other type of picketing, which has kind of changed, is what we call signal picketing. And we won't spend a lot of time on that, but if you've worked for a union, or if you know somebody who has worked for a union, the union often refers to those who are anti-union as rats. Okay, that's kind of the terminology. For a while, it was decided, okay, based upon some of the things we can do under the National Labor Relations Act. We won't wear these signs. We won't patrol back and forth. Instead, and I mean literally, they get an 18-foot, 20-foot inflatable black rat out there and just post it on the premises. All right. Up until just recently, that was generally prohibited. Recently, with the Obama administration, there has been some change to that, and that may not be considered picketing now. It may be considered legal. So keep that in mind. That's what we call signal picketing. Not a big deal, but you see it some in the employment law context. All right. The other thing that, as we talk about this picketing, this striking, this boycott, I don't want to spend a lot of time on it, but do want to bring to your attention this idea of hot cargo clauses. Now, a hot cargo clause, H-O-T-C-A-R-G-O, is simply a clause that says, all right, employees can refuse to handle the product of any employer involved in a labor dispute. All right. And the National Labor Relations Act prohibits language in a collective agreement that authorizes that conduct, such as refusing to handle goods produced by a non-union employer or by an employer who's being struck by a different union. So let's say that we have Mattel out here who is not union, all right, and we have a company that, let's take I guess we'll go to the extreme with this. Let's say that we have the person that makes the plastics that's used in the Barbie dolls that is union, all right? So Mattel may not be union, but we've got the people that are making the plastic parts union. Those people it would be prohibited generally by the National Labor Relations Act for some union to say, you know what, our buddies over here that are making these parts are being used by Mattel, which is non-union. We really think Mattel should be union. So it would be a prohibited boycotting or prohibited act to say, whoa, anytime Barbie dolls come in, we're not going to ship them or touch them or handle them. That's what they call a hot cargo clause, because it's hot, you don't want to touch it type of thing. And courts say, you know, generally, we're not going to allow you to agree that you can refuse to handle certain products. Now, there are exceptions to that. The garment industry, it's generally allowed that you can engage in that kind of, so that you don't touch products that may be manufactured by a non-union. That's an exception. The construction industry may also be an exception. So if you get that, not a lot of time on that, but I want you to know a little bit about what a hot cargo clause is. Now, so what happens if you have a union who's engaging, we know what striking is, we know what picketing is, we know what patrolling is. Those are all perfectly legal unless you get to that secondary activity. That is where you're focused on Toys R Us versus Mattel in the example that we've used throughout this lecture. What are the remedies? Well, if you've got a violation that comes in, you file a complaint. If you're Toys R Us, you go to the National Labor Relations Board and you say, hey, we're not doing anything wrong here. They're fighting over wages with Mattel, and yet they're picketing us. What do? As Toys R Us, you go to the National Labor Relations Board and you try to get an injunction against the picketing. And the injunction, the NLRB or a court would come down and say, you can't do this until we can determine whether it truly is a secondary activity or whether you're just trying to notify or inform the public about a particular situation. And that's really how you do it. You try to go to court and you get an injunction for it. Now, other thing that I'll tell you with regard to this picketing and patrolling, keep in mind that the Taft-Hartley Act, and we've talked about it, mentioned it briefly in the past, it added certain sections to the National Labor Relations Act which has provided for injunctions for stalling strikes when they threaten national health or safety. Keep in mind we're talking primarily about private situations here, and the striking is allowed in the private sector. But even in the private sector, the law does allow strikes to be stopped or at least forestalled when those strikes would threaten national health or safety. And what happens is the president appoints a board of inquiry to look at the issues involved in this dispute. The U.S. Attorney General can secure an injunction up to 80 days while the Federal Mediation and Conciliation Service attempts to resolve the dispute. So that kind of, last week while we were talking about collective bargaining, this week we've kind of focused on patrolling, picketing, strikes, those types of things, and how they affect the private sector. So next week we'll wrap up with just a short little bit on public unions and how those are a little bit different. And we'll see you then.